Hi, it's Mike DelSignore, Massachusetts OUI lawyer. In today's video, I want to explain what happens if you're charged with OUI and your case is going to be heard in the Orleans District Court. So if you're arrested for OUI and you're on vacation with your family in Cape Cod, remember, these cases are very winnable cases. So if you have an out-of-state license, it's important to fight it equally as if you have an in-state license, because your home state is likely to find out and suspend you for OUI. But your first date is going to be the arraignment. At the arraignment, you'll enter a not guilty plea, formally advise of the charges, and the case will be set down for what they call pretrial. At the pretrial, we'll be able to get a copy of all the evidence, any reports, video evidence, booking videos, body cameras, and fully evaluate the case. Now, a couple things people want to know right away about your license. Your license, if you took a breath test and you were over 0.08, you can get it back within 30 days. Just request a hearing before the 30 days end so you don't wait any more time period. You can schedule it prior to 30 days so to make sure your hearing's on day 31. And then you'll have your license back while I'm fighting the case. Now, in some cases, let's say the evidence comes back and you end up taking a plea later in the process, you'll have another 45-day license loss. But our goal would be, if you got your license back, would be hope that the evidence that we would get would help us get a breath test excluded or help us win the case at trial so you have no further license loss and avoid an OUI conviction. Now, if you refused a breath test, you're in a better spot in terms of court. There's no breath test. There's no objective evidence to show you were impaired. The problem is you're without your license for 6 months. So you're going to have to be able to figure out how to get a ride while we fight the case. That's one of the things that people ask all the time. Geez, everyone told me to refuse. Now you're saying I can't drive for 6 months. That is sort of the catch-22 of it. If you weaken the government's case by refusing, but they make things harder for you because you can't get a hardship on the refusal, unless you plea the case out. So let's say the case is bad. Let's say you crashed, admissions, it's a strong case even without a breathalyzer. You might want to resolve the case and potentially see if you can get a hardship license. But hopefully you'll have a case where we can win, where we'll get the case to trial as fast as we can. Now, fast in court terms is still 4 or 5 months. But if we get it before the 6 months, we get a trial and you found not guilty, is a presumption or reinstatement of your license. So there is that ability to reinstate your license early, prior to the 6 months, if you're found not guilty. Now, you're going to hear or see in forms that you have this right to appeal the refusal suspension within 15 days. I used to do that all the time. I've probably appealed over 100 of them. I don't appeal them now on first offense OUIs because, and I've seen this personally, what the registry often does is they'll suspend your license for immediate threat when you file the appeal. So don't appeal that. Those suspensions were very difficult to overturn. I got very few of them out of all the ones I appealed. They were difficult to win. I did have some success with them, but now the registry is taking out other suspensions, so it sort of defeats the purpose. You're just going to make things more difficult for yourself. So what do I look for in determining whether you can win the case at trial? I look for the field sobriety test. I've cross-examined hundreds of officers on these tests. I kind of know what they will say, what they will, how they will testify at trial. And a lot of times when I look at the field tests in the police report, I can make it seem like you passed the test. I'll point out all the things you did well. These are difficult tests. Most people don't follow instructions perfectly. So the assumption is you follow every instruction perfectly, you have perfect balance, perfect coordination, and you can perform all this on the side of the road under the pressure of the thought that you might be arrested if you make a mistake. So there's a lot going on there that doesn't necessarily mean that if you make a mistake, you're under the influence of alcohol. So I'll explain that to a judge, to a jury, and if you have medical records, so show you have problems with balance. For example, today I had a case on trial, client had a bad toe. We presented those medical records. I had a case a week ago in another court. Again, it was a knee injury. So medical records can explain problems with balance. Sometimes, in some cases, I might call your wife or girlfriend, say, hey, you don't have good balance. So it doesn't always have to be medical. Evidence can be testimony, can be documents. It can come in different forms. So there's different ways we can do this. But when I look at the case, I'm going to look for things that contradict, to refute the argument that you're impaired. Like I was explaining today to someone in court, on these cases, we need to show reasonable doubt. We don't need to win every point. We're not going to win every point generally. Generally, they're going to have their strong part of the case. But what I want to do is find a part of the case that I can focus on to say that's reasonable doubt. To say, okay, the officer had probable cause to arrest you, but we don't get beyond a reasonable doubt because of these facts. Whether it's good driving, good field test, that you're polite, cooperative, respectful, alert. Those are all things that I look for and things that I've used to win cases in Orleans District Court and courts throughout Massachusetts. So questions on an OUI in Orleans, call, text anytime, 781-686-5924. I'm here to help. My passion is helping people avoid a conviction for OUI.